get a shot right through into a boat of blue. It's no problem of mine, but it's a problem I find, living the life that I can't leave behind. There's no sense in telling me the wisdom of a fool won't set you free, but that's the way that it goes, and it's what nobody knows. And every day my confusion grows. Every time I see you falling, I get down on my knees and pray. I'm waiting for the final moment. You say the words that I can't say. I feel fine and I feel good. I feel like I never should. Whenever I get this way, I just don't know what to say. Why can't we be ourselves like we were yesterday? I'm not sure what this could mean. I don't think you're what you seem. I do admit to myself that if I hurt someone else, then I'll never see just what we're meant to be. Every time I see you falling, I get down on my knees and pray. I'm waiting for the final moment. You say the words that I can't say. See you falling, I get down on my knees and
morning, everyone, and thank you for joining us today at Bloomberg headquarters. My name is Kathleen Moreau, and I'm a senior account manager here at Bloomberg BNA. We're delighted that you could join us this morning for this continuing legal education course entitled Making Sense of the World of Delaware Corporate Litigation. Before we begin, actually, as part of our commitment to our clients and the legal community, we're pleased to partner with DLA Piper this morning to bring you this panel who will present on obviously a very timely and constantly relevant topic. And before we begin, and John, go ahead and introduce the rest of the panel.
Great. So thanks for coming this morning. The title of this program is Making Sense of the World of Delaware Corporate Litigation. It's an aspirational title. But to the extent a panel can make sense of some of it, or even all of it, it would be this panel. It's a diverse panel in a different sense. And when you look at it, we've got people from very different backgrounds. To my immediate left, we have Vice Chancellor Laster from the Delaware Court of Chancery. To his honor's left is Joe Spallerhand, who's one of the most widely respected securities and corporate governance litigators in the country. He's a partner at Weil Gotshal. To his left, we have Kieran Hughes, who is, and I want to get this title correct, he is the VP of Financial Lines Claims at AIG. And then to my right, we have Minor Myers, who is a professor at Brooklyn Law School, and he's also aspiring to be one of the leading scholars in the country. And if you read his full works that are summarized in our papers here, you'll see that he's well on his way. This is going to be a very open discussion. I don't think these programs are very good if people simply lecture at you, so there's going to be a lot of back and forth, and we encourage people to raise their hand at any particular time and ask questions. Delaware likes to talk about the fact that we benefit from having the most widely developed body of case law, and it provides certainty and guidance for people. But the implementation of the law through our judiciary has been critical over the years because so many states have simply copied our code, but they can't copy our judiciary. And we benefit from the fact that we're very careful about who we put on the court, and we have very sophisticated practitioners and very intelligent judges. But one thing I think sometimes gets underestimated in all of this is the forums like this. Very often, before a member of our judiciary is going to issue an opinion on a developing area of law, there's been a lot of debate about it. Our members of our court are very, very good at going around the country and doing programs like this, and they benefit to have these issues debated back and forth and hearing from different perspectives. And so we would encourage you to participate in that dialogue. The first topic we're going to talk about has been a topic that's been on the list for these programs now for several years, and it starts with banker conflicts. And His Honor really is the one that got the ball rolling on this back in 2011 with the Del Monte case. And if everyone recalls, we're not going to talk about a lot of detail about some of these cases, but if everybody recalls, the financial advisor for Del Monte went out to some of its other clients and tried to sort of trump up interest in the company. There was no teaming agreement signed, and ultimately the company said no. Later on, the financial advisor went back to another private equity firm, and one of the other parties, in violation of the no teaming agreement, they went back and approached Del Monte to get the dialogue started. Then the financial advisor went to Del Monte and asked for permission for the other bidder to team up in violation of the no teaming agreement and asked to be able to participate in the buy-side financing before an agreement on price had even been reached. And ultimately, His Honor found a real problem with that and enjoined the deal for, I believe, was it 20 days?
20 days.
So,
doesn't sound like much.
Your Honor, I guess a couple of questions about that. In hindsight, would you do anything differently when it came to the remedy?
I wouldn't do anything differently in that case. And ultimately, there wasn't any topping bid that came through, so you could question the ultimate effectiveness of the remedy. But I do think that the remedy was appropriately tailored to the violation. And since it was a premium deal that the stockholders could accept, in some ways it created a best of both worlds situation where they could take the deal, take the bird in hand, and then have the potential upside if ultimately the facts proved out to show that there was bad conduct that resulted in damages. Obviously, actually proving those things at a trial is difficult. There were a lot of good defenses, et cetera, but it still created the possibility of that happening, and you didn't risk losing the deal. I think the alternatives were, one, lecture and let it go. Delaware has done a lot of lecturing and letting it go. So the only reason I think you can say that I get some credit for starting the ball rolling is because Del Monte was the first case that actually imposed some form of remedy rather than just saying, hey, this is problematic behavior. Hey, you really ought to think twice about this. Hey, this is something that we're really concerned about. I mean, for some reason, when then Vice Chancellor, now Chief Justice Strine, said all those things in Toys R Us, for some reason what people heard was, green light, this is cool, let's do it. What he actually said was, be really, really careful. It seems to have been done right in this situation, but it's a very problematic practice. We're worried about conflicts, and so you ought to think twice and make sure you're crossing all your T's, dotting all your I's. But somehow the message that was received was, game on. And so that was one option, was to just lecture again. And at some point, I mean, I have kids. Probably a lot of you have kids. And at some point, if you keep saying to your kids, don't do that, but you don't actually impose any consequence, they stop hearing you, right? They don't listen to mom and dad anymore because they know that saying don't do that really doesn't mean anything, right? Then the other, so that was one end of the spectrum, which again I didn't think would have been terribly effective to give yet another cautionary tale. The other end of the spectrum would have been to enjoin the whole deal, which is problematic at the injunction stage because you really don't have the same degree of confidence in your factual findings that you would at trial, and you're taking a big risk in terms of foreclosing what could be a value-maximizing transaction. And you're also taking the decision away from the stockholders, who are people who have real money, real decision-making authority, and actually should be deciding on the result. So personally, I mean, I'm biased because I did it. We all tend to generally support the things that we've done. But yeah, I would do it the same way again.
Well, there was a lot of sky is falling memos that went around after the opinion came out. But I don't think anybody could condone the conduct. So it was one of those cases where bad facts made for a supposed rule of law that everyone now has to deal with. And the case that followed very quickly on the heels of Del Monte was the El Paso case. And Joe, I believe you represented Kinder Morgan in that case. So do you want to talk a little bit about that?
Sure. It's always fun going after the Vice Chancellor, but I'll try. The Kinder Morgan El Paso case is one which ended in a $125 million settlement funded by the gentleman to my left from AIG. So I think there was absolutely a remedy that was pretty painful down the road. The facts were somewhat incredible, and the Chancellor Strine, now the Chief Justice, had a field day with him at the argument. I would recommend anyone, if you want to see two major New York lawyers taking a browbeating and getting their asses kicked, you might want to read the transcript of that argument. It was painful being there, but it's funny afterwards. So the facts, seemed like they were out there and were pretty easy to deal with. Goldman Sachs had been the lead banker to take Kinder Morgan private, and then Kinder Morgan had gone public again, and Goldman Sachs still owned 20% of Kinder Morgan and had directors on the Kinder Morgan board. Kinder Morgan makes a proposal to acquire El Paso. And obviously, what happens, Goldman Sachs turns out to be the longtime investment banker for El Paso. And El Paso had already been working on a spin-off and a restructuring. So they were deep into advising their client. So you have an obvious conflict now, right? You have Goldman Sachs owns 20% of the company, Kinder Morgan, seeking to acquire El Paso, and Goldman Sachs is the financial advisor for El Paso. So you got to give people some credit. This is not a conflict that was not foreseen. The board saw it at El Paso, and what they said was, you, Goldman Sachs, you can continue to work on the recapitalization spinoff because it's good to have an alternative when you're negotiating with the buyer. But don't you dare work on the transaction with Kinder Morgan. We'll bring in another banker to negotiate with Kinder Morgan. And that seemed like a pretty good resolution, except for one issue which the chancellor was very attuned to, and that issue is called the league tables. Goldman Sachs did not want to give up accreditation in the league tables for working on this blockbuster, huge transaction. And unbeknownst to us on the Kinder Morgan side, when their engagement letter was actually signed, almost a day before the deal was signed up, because these engagement letters often get deferred, lo and behold, it says Goldman is retained to work on the transaction, capital T. And the transaction is defined broadly to include the deal with Kinder Morgan. Then in the middle of the deposition of the Goldman Sachs banker, it turns out, a very well asked question by a plaintiff's lawyer, that the Goldman banker was part of the Goldman group of bankers who had invested in the Kinder Morgan going private, and therefore he had a couple $100,000 financial interest in Kinder Morgan. Now, to a Goldman partner, a couple $100,000 is probably an immaterial financial interest, but that was still another very unhelpful fact. And ultimately, the chancellor, really following on what the vice chancellor just explained, did not enjoin the deal, even because of the conflict, because there was no other bidder, and he did not want to take the chance that the El Paso shareholders would be prevented from deciding for themselves, once this was all disclosed, whether they wanted the deal, which they ultimately did. And ultimately, we had to settle with the help of AIG and other carriers and Judge Weinstein mediating for $125 million, which is one of the highest I'm not proud to say, one of the highest post-closing settlements. But I've got an even better one for you, lest you think that the conflicts story stops there. We argued a case on the Friday before Memorial Day. Wagacho represents Signet, a British company which was buying Zales. You know, he went to Jared's, every kiss begins with K. I always go to 47th Street, but apparently people do go to the mall outside of New York to buy engagement rings. So we make an unsolicited approach. Signet sends a letter to one of the directors of Zale and says, we're thinking about acquiring your company. It'd be a cool combination. We'd be the two biggest companies and, you know, one, a lot of savings, all that stuff. And that's confidential letter. The very next day in New York at BAML, Bank of America's headquarter building right on Bryant Park on 42nd and 6th Avenue, there is a luncheon and a meeting between BAML, financial guys and bankers, with Signet's CEO and CFO, our clients. And it had been a regularly scheduled meeting. They stay in touch. These were the bankers who work that segment of the industry. And during lunch, you know, hello, they're eating a sandwich, they hand out a book. And the book suggests that Signet acquires Zale. All based on public information, of course. And by the way, you didn't have to be a genius. These are the two top players. And they get this book. Our guys go back to Akron, where they're based. They take the book, throw it on the pile of the 30 other cold call investment bank books they've received over the last 2 years, suggesting that Signet acquires Zale, and forget about it. A month later, the process is heating up, and the targets board, Zale, is now ready to hire an investment banker. Who is their longtime investment banker? Of course, Bank of America, Merrill Lynch. The board does the right thing. the board says to the bankers, before we hire you, please tell us what conflicts, if any, you have. Well, we don't do really much work for Signet. We have a couple bank accounts and some malls. I think it's $2 million in fees over a bunch of years. Board says, great, you're a long-term advisor, you're hired. In preparing the proxy statement, and to the credit, I think, of the lawyers really working on the proxy statement, this comes out, this being the cold call that BAML did to Signet, suggesting they acquire Zale. And we actually disclose in the proxy that in the course of, the last paragraph of the background section in the proxy says, in the course of preparing the proxy, the lawyers discovered that BAML had made this presentation, but Cravath, which represented the target, Zale, said they did an internal investigation. They talked a while. It was all public information. The book went on a pile. It was never consulted nor relied upon by, by Signet. And so there you have it. We file the proxy. What happens next? Obviously, we have all the shareholder suits. And the case then comes for an injunction on the Friday before the deal is supposed to close, Memorial Day weekend. It was the same day that Andy Bouchard was the investiture as the new chancellor, and Vice Chancellor Parson denied the request for a preliminary injunction. There was no other third-party bidder relying on Del Monte, El Paso, other cases, saying that he couldn't deprive shareholders of the chance to vote now that it had been disclosed, but the process had been less than ideal, and the case will continue as a damage case. There was a vote, the deal was approved, and it's now closed. But what I leave you with is, what is a board supposed to do? I mean, remember, the directors are the ones that are in the target zone. They're the ones that are alleged to breach their fiduciary duties. They asked the right question. And the banker, and by the way, BAML's point was, they viewed the meeting as so inconsequential as to what they do on a regular course of business that it never even occurred to them that this was something that had to be disclosed. And I would ask the Vice Chancellor, I always thought and counseled my clients that you can hire a conflicted advisor, that a director can hire a conflicted lawyer. I mean, as lawyers, we know that if you disclose a conflict and the client is willing still to hire you because you're the best guy around, that's okay. Can't directors do the same thing as long as they go in with their eyes open?
So the thing to remember about these situations is the standard of review. And the standard of review under these situations is reasonableness. And why is reasonableness the standard of review? Reasonableness is the standard of review because selling the company is not something that the management team or the board does every day. It is a different situation. There are different pressures involved on management. There are different pressures involved on the board. It is a big fee event for the advisors. A lot of times advisors will have been given freebies giving freebies over the years. This is their time to get the actual paying job and get the big payday. So there are an awful lot of interests going on that cloud the picture in the boardroom. And so what we do in Delaware is we don't say, hey, this is so bad we're going to actually apply entire fairness, which is our highest standard review. That's where the court comes in and says, okay, did you really do it right? But we also aren't going to give you the clean pass that Mr. Allahan wants, which is just to say, oh, well, did you know about everything? If you knew about everything, you made a decision. Okay, then it's all good.
That's the question.
So where we are is we're in this intermediate space. And what this intermediate space is, it's still broad. So again, I think of it as a pyramid, three-tier pyramid. Entire fairness is at the top. Very, very narrow range of discretion. Is there still some discretion? Sure. Why? Because I don't think I'm always right about things. And if you've given me a really, really good, compelling explanation, yeah, I'm going to give you a little bit of deference. At the bottom, we have super, super wide business judgment rule. That's like from that wall to that wall. Big, huge. You basically get the deference. In between, it's about as wide as the five of us sitting up here. So it's still pretty good. I mean, you know, somebody in the back of the room could throw a baseball and get it in here pretty easily. But what it means is you have to have a good explanation. So if somebody like Mr. Allahan comes in and says, look, the board considered all these things, they thought about the benefits of doing this, and here are the really good reasons why the benefits make sense, you're going to be fine. Now, if your explanation of why the benefits make sense sounds really cookie cutter, and it just happens to be like reasons that you can just apply in any case, I mean, it's great. It's like the rubber stamp reasons. Hey, bring us the list of reasons for the conflict. Okay, good. I got the list. Boom, done. That's not going to go so well. And if your reasons actually conflict with things, like you actually didn't act consistently with your reasons, or there are other reasons to question, reasons for the judge to question the bona fides of your reasons, that's when things aren't going to go so well for you. So what I would say, and I obviously wasn't the judge in El Paso, but El Paso looked to me like a situation where they came in and they said, we had good reasons. And one of the reasons that we had was we walled off Goldman. But then the actual way they implemented the walling off didn't wall off Goldman. And when you supposedly make a decision based on reasons that then prove not to be accurate or fully implemented, that's the time when you start to have problems.
So we're going to see more and more, I think, the need for a second financial advisor. And Joe, you can correct me if I'm wrong about this, but my recollection is that Goldman participated in the negotiation of the retention agreement with Morgan Stanley and negotiated it in a way that the only way Morgan Stanley was going to get anything at all is if the deal that was already on the table or one similar to it was done. So, Your Honor, would it be fair to say that that's just simply a bad idea? Let's get the first advisor out of the room when you're negotiating.
That was clearly something that the Chief Justice focused on as a problem. Because if what you're trying to do is insulate an incentive, like you don't want them backdooring their incentive.
If you bring in a second financial advisor because the first one has some kind of a conflict, what you're hoping to do is that the second advisor works in a fashion where their work is not tainted by the conflict. It's not going to be very helpful if the second financial advisor says, yeah, we relied on the first guy, because the first guy is the one that had the conflict, and the chancellor did pick up a lot of that in El Paso, and in the case, in that case, that really was the problem, that the second one in really didn't have the independence, and I think if the second banker in had the independence, it would have worked differently.
So out of deference to the, oh, yes, a question.
In the last year, I was involved on a special committee in a hostile acquisition by a related company. In the process of interviewing the financial advisors, we talked to both large global international banks and smaller boutique firms. One of the large global banks insisted they had no conflicts. We went through the same list of questions with all of them. We hired them. We found out shortly after we had signed the letter through a third party that the commercial banking arm of this investment bank had significant financial interests in the hospital, in the company that was the team and made the hospital bid. We fired them. Had we not fired them, how did the courts have viewed the fact that we had depended upon the word of the investment bank that they had no financial interest in the company that was trying to take the hospital?
Yeah.
And in fact, would have signed something that said legally they had no conflict. But we found out and we later that the commercial banking arm, which is arguably
Bigger.
separate.
Sort of separate, yeah.
Not really, but not really.
No, I hear you. I mean, look, so I think a couple things. First of all, assume that type of situation where there is some issue that proves out and is discovered in discovery, but was not known to the board. It's pretty hard to blame the board for that. I mean, particularly if the board is asking the right questions and is getting inaccurate answers. So that's the type of situation where I think, would you say that technically the board had breached its duty of care? Well, this is where my defense lawyer colleagues get all itchy. They say, like, well, how could the board have committed any breach in that situation at all? But I think conceivably you could say that the board might have breached its duty of care, but that because you all were misled, again, arguably, but let's assume it proves out, the onus falls on the investment banker. Now, that's assuming it's like secret till the end. And it just comes out in litigation, and there's actually evidence that there's a skew in the process and harm, etc. That would be a situation where I would think the board is actually going to be okay, you're probably going to be exculpated, and the problem is going to be on the aiding and abetting side with the investment banker for creating the problem for you. Now let's focus on your situation. I mean, that's the kind of situation where you guys had a tough decision to make. And you're now in mid-process in the same type of decisional scenario that you would have been at the beginning of the process had this been disclosed. Do we continue with these folks despite their conflicts, or do we hire these folks despite their conflicts, continue in your situation, or do we bail? Except you've got the additional complications now that you've been once burned by them, right? So how does the court look at that? I get out my reasonableness glasses. Again, I don't give you my business judgment glasses. I don't give you my entire fairness glasses. I give you my reasonableness glasses. And I would listen to you and assume you had stuck with them, because I think by firing them, you took the route that it's really hard to question. I think that's that's part of what I think judges have some incredulity about. I mean, we know investment bankers and advisors, lawyers too, they're all very smart people. They're adding value to situations. We understand why you want them. We also understand that you trust certain people. You've worked with them for the years, etc. But, there are a number of good investment banks, just like there are a number of good law firms. And if somebody comes to you, if you're doing a beauty contest or something like that, and you have one investment bank that's got X, Y, and Z problems, and you've got another investment bank that is equally good and doesn't have those problems, and you guys go with the one with the problems, a court starts thinking, well, why would you do that? How tight are these guys with management? Like, what kind of advice are they really giving? What's going on there that I don't understand about why they made the decision they did? Now, all that may prove out again, but I'm just saying, these are the types of spidey sense tinglings that you get when you see these types of facts play out. So, what I would want to do is I would want to listen to your explanation. Again, by firing them, I think you basically took the high road. But had you not taken the high road, you would have had to come forward with some really good story, like, we were at such a critical time in the process. And you'd have to give me reasons why it was a critical time, because we were at such a critical time in the process. That's like the rubber stamp reason. You can always be at a critical time in the process. Oh, it was a critical time in the process. Well, why was it a critical time in the process, right? But if you had come and been able to say, like, look, we thought about this commercial thing. They swore on, 5 Bibles, 5 Qurans, and whatever the applicable Buddhist texts were, that this would never happen again, and there really were going to be firewalls, etc. It was a critical time in the process because of X, Y, and Z. We talked about it. We asked Joe what to do. We vetted it with everybody, and you know what? We decided that given the risk reward, we needed to go forward. That is a position that you will probably have to defend at trial, but it's a position that could win.
You have to ask the right questions, right? I mean, yes. Would you agree that not every relationship on the commercial banking side is the kind of conflict or material conflict that impacts the mere fact that the commercial side of the bank might be part of a credit facility of 1 or 2 of the people that are in the bid process, and it's not going to change, the interest rate or the money they're going to make. I mean, I think there are a lot of legitimate explanations that could be provided to a court, particularly if it's a niche industry, and you've already retained the bank that is the most qualified in that particular industry.
I agree, and that's why I want the specific facts. I mean, the thing that worries me, and it continues to worry me, is I remember when Solomon was acquired by Travelers, eventually became Citibank. Like, I remember when these big banks bought these investment bank houses, and the reason they did it was because they wanted the synergies that would come from getting the advisory side and leading to the loan work. Like, that was part of the announced reasons for these deals, which is basically going out and saying, we want to work the conflict. I mean, and look, I hear you. Like, from a financial side, it's a great thing to work. It's great. But you've got to then understand that if you're gonna have the conflict, you've got to take responsibility for the conflict. You got to deal with the conflict. You can't just have the upside of the conflict, i.e. the business side of it. You've got to understand that there's risk that comes with that.
Well, the lawyers kind of do it on a different scale all the time,
do.
right? The transactional lawyers negotiate the deal. Somebody comes in and challenges it, says it's a product of a breach of fiduciary duty. At some point, they may tag the lawyers, but all along, the litigators are going to go and defend their partner's work.
No question. No question.
Questions?
Yeah, it's been a long time since I've practiced law, so I start with a disclaimer. This may have been the subject of a decided case already. But on the subject of conflicts of investment banks, what about success fees for being the advisor plus a fairness opinion?
So, I mean, there has been a lot of discussion on this. My sort of 2-cent summary is contingent fees are incentive aligning once you're in the realm of getting max price. There's some deviation once you get down to sort of like, do we push for a little bit more and risk jeopardizing the deal, or do we take the bird in hand? There's a little bit of divergence there. Where it's incentive divergent is on sale or don't sell. But that's an incentive that everybody understands. It's the same type of incentive that I have when I hire a real estate agent who's just on a contingent brokerage fee. Like, if I'm selling my house and I hire my real estate agent and I've priced my house at $325 and I really think $325 is what I want for my house, and I've got an offer at $315, and my real estate agent says, you know, Travis, I really think you ought to take this. It's a really good offer. Yeah, you really ought to do it. Like there's no doubt in my mind that I don't think he or she is, and my real estate agent is actually a man, so you see. I don't think like he is misleading me. I think he's actually a genuine, honest guy. But it would be silly of me to ignore the fact that his compensation is based on this deal, and that perhaps even at a subconscious level, that could have an influence on him. But because it's all out in the open and I know all this, I can take that into account. I can judge all these things. So I don't think that this is a disqualifying interest in any way. It's a point, obviously, the board has to understand what the economics are. And I actually think also the stockholders have to understand what the economics are. You know, we've had this sort of squishy-ish law in Delaware, like you have to disclose the details of your compensation arrangement if the differential is big. Well, you know, 0 to a lot is big, right? That's a lot. And the other thing that I think personally is when somebody tells me it's a customary fee, I have no clue what customary fee means. And from what I do know from previously litigating these deals and now seeing these deals, is the range on customary fee, it's about as wide as the range I gave you for business judgment deference, all right? Big range. So telling me customary fee doesn't really tell me much. So that's a long-winded answer to your question, but I think is it a theoretical conflict? Yes. Is it one that the board can effectively manage and does effectively manage? Absolutely.
So out of deference to His Honor, we're not going to talk much about the rural metro case, but of course that's the latest case on banker conflicts, and you know, sort of the gist of it is that.
And deference is it's still going on, so like I can't say
really
much about it because it's still live.
So the gist of it is that the bank misled the board in order to ultimately get buy-side financing, and he tagged the financial advisor with aiding and abetting liability. And the controversial part of the decision, to the extent there is a controversial part, and I think probably there is, at least from a legal point of view.
From what I hear from my attorney friends, there are lots of controversial parts.
You know, in order to tag the financial advisor with aiding and abetting liability, he had to find an underlying breach. And then the question is, in finding an underlying breach, how do you determine that the directors who have now settled out breached their duty of care that was therefore aided and abetted? And here's where I'm going to play confused, and it may be that I am actually confused. My understanding of Revlon is that Revlon came about because the board favored one bidder over the other, and the court ultimately said, look, in an exit transaction, all the stockholders care about is how much money they're getting. And so the Revlon obligation is to get the best price reasonably available. But it's also my understanding that Delaware law has only two fiduciary duties, care and loyalty. The duty that you follow in getting to the process where you have that choice is the duty of care. And yet our Supreme Court says that the threshold for liability for the duty of care is gross negligence. But I also know that if I was standing before Your Honor defending against a preliminary injunction motion, I couldn't say, look, Judge, I understand the board was negligent, but they weren't grossly negligent. And therefore, they haven't satisfied the colorable claim prong of the PI standard, and therefore the motion should be denied. That won't work. So what really is the standard? I think reasonableness is the gross negligence standard. It's outside the bounds of reasonableness. That's negligence.
Well,
but
push back on you in that, but I hear where you're coming from.
I mean, at least it's close.
I can tell you how I think about it, which, that, at least if you're in front of me, is helpful. This may not be right at all, because these are areas that the Delaware Supreme Court hasn't written on really since, well, Lyondell was sort of the last time, and that was 2009. And the interaction of the standards they haven't done a lot on. But I think there are duties and there are standards of review. And so the question that I have to ask is not like, did you breach your duty? This isn't a tort claim where there's a clear standard of care, and the standard of care is medical practitioners in the community, and we measure it, and you breached it or not. We have three different standards of review. We have this escalating pyramid that I described, and so the first question I have to ask is, what standard of review applies? Now, if the standard of review is entire fairness, you have to show that you followed not a non-grossly negligent process, not a reasonable process. You have to show that you followed an entirely fair process. So that's the fair process aspect of entire fairness. We don't call it the non-grossly negligent aspect. We call it the fair process aspect. Now that is a manifestation of the duty of care being judged under what? A standard of review. I think that same logic, to my mind, applies when I step down to reasonableness. So I'm supposed to judge whether you acted reasonably. I don't just judge whether you acted fairly. I judge whether you acted reasonably. Now, if you're in the business judgment world, I think you're exactly right. The standard of review for a care breach in business judgment world is gross negligence. And look, I could be wrong about that. The Supreme Court could very well say, no.
See, I always thought entire fairness really had nothing to do with care and loyalty only in this sense, that we just didn't make conflicted transactions void. So they're voidable, and therefore you can go forward if you can establish that they're entirely fair. So they're really viewed differently than simply applying care and loyalty, even though that's the standard again, you have to satisfy.
I'll give you Laster interpretation, which is as good as far as it goes. What I would say to you is, John, that's true for 144. And 144 is our statute that indeed does allow you to validate void or voidable transactions. And one of the ways you can validate a void or voidable transaction is by showing it's entirely fair. But that is separate and apart from the fiduciary duty analysis. What that means is, if you show entire fairness, you get the double win. Because the first win you get is you get to blow away any type of invalidity challenge. The second win is you get to blow away any type of fiduciary duty challenge. So if you prove entire fairness, you are good all around. But entire fairness just happens to be the standard that we apply both under 144A3 and in the fiduciary duty context. But again, I could be wrong about this. I mean, there are Delaware Supreme Court decisions that you can interpret. I mean, I think they're business judgment rule decisions. But you can interpret these Delaware Supreme Court decisions, and fine advocates do, as saying Gross negligence is always the standard for care. It shall not change. I think you apply the standard review, and then where you get into care versus loyalty is whether you're going to impose personal liability.
Somebody want to help me out here?
Yeah, I mean, I've been thinking a lot about this, and perhaps this is way too detailed, but what the Vice Chancellor said you should really write down and chisel it in stone if you litigate in Delaware. The only question that matters when you're in a Delaware Chancery Court litigation is what is the standard of review? If it's business judgment standard of review, the defense wins. I mean, generally that's the rule. If it's entire fairness standard of review at the top of the pyramid, you go into trial, which in my world, you've lost already, because who knows what happens at trial. That's very risky. And these cases involve a ton of money. And I think the frustration we have as practitioners is the question is so important, what's the standard of review? But often, if you're facing a very talented plaintiff's firm, you can't get it answered on a motion, because that question itself is wrapped up in factual issues. Was there a conflict? And I think what's happened is entire fairness has gone from that little top of the pyramid and has gotten to be much wider than perhaps the Vice Chancellor acknowledges, because I used to think it applied in Conn v. Lynch. They said when there's an 800-pound gorilla in the room negotiating a deal, because that 800-pound gorilla is the majority owner of the company that he's negotiating to take over. Well, it's hard to negotiate with someone who owns 80% of your stock, who controls you. And that's where entire fairness really started. But yet the law, and I think the Vice Chancellor absolutely correct, if there's a conflict that prevents you from getting business judgment rule, because business judgment rule says the directors have to act in an informed, good faith manner. If there's a conflict they don't know about, then maybe they can't get business judgment. Then boom, you're rocketed to the top of the pyramid, entire fairness, and you're going to trial. And it's hard to get the answer to what standard is going to apply at any point.
Well, you're
and
in
I
trouble.
think the Chancellor said in
if it's
Peru,
entire fairness.
and I think the Chancellor, now the Chief Justice, said in Southern Peru that was frustrating, that he couldn't even answer the question in the middle of the trial.
Yeah, and I think, and part, a lot of what and he's the Chief Justice now, so there's good sense for me to do this. But I mean, a lot of what I try to do is operationalize some of the principles that he's said. And I think part of what he has said is, let's figure out ways to get people answers on standard review earlier. And so part of what I think about in terms of reasonableness is, I do think reasonableness is materially different from entire fairness. I'm giving your folks deference on reasonableness. And if they come up with a good explanation, and they usually have a good explanation, they're fine. But I think they ought to know up front, as early as possible, that it's a situation where it's reasonableness. Not fairness, but also not business judgment.
But the problem is good plaintiff lawyers, and generally that's the only type I deal with, say, well, there are lots of facts in dispute, Judge, and so I need to go through discovery, and you can't decide that it's business judgment rule or entire fairness, because we need to explore the conflict, we need to figure out what the directors knew or didn't know, and then you're off to the races. That's really a very powerful weapon in the hands of talented defense lawyers.
Well, in the murkier area is if intermediate scrutiny is the standard of review. So I think what we can all take away from this, if we're talking about a Revlon situation, don't argue to Your Honor that with regard to the care duty, that gross negligence is the standard that they should be held to, that it's reasonableness.
Yeah, I mean, look, again, I think it is certainly at the injunction stage, it's reasonableness. And I don't understand what would change after that, because the standard review, it's not like we have a set of injunction standards review and a set of non-injunction standards review. We have an injunction test. It's got 3 elements. One of them is reasonable probability of success on the merits. But when we kick into that, we use standards review. So if you're in entire fairness land, and that's going to be the standard review at trial, that's the standard review at the injunction phase. If it's going to be business judgment at trial, it's going to be business judgment in the injunction phase. And to the extent there are drivers for enhanced scrutiny, as I understand them, they don't change between injunction phase and post-injunction phase. So yeah, I think I've been told by these Delaware Supreme Court precedents that reasonableness is the standard. And then, but to find this is also key though, and I don't want anybody to miss this. Let's assume that Laster says, your conduct was not reasonable. It fell outside the range of reasonableness. That does not necessarily mean you were liable. All right? That means that there is a breach of some type, and now I have to parse it. And I have to parse it at that point, whether it's a care breach or a loyalty breach. If it's a care breach, exculpation will kick in. And then it's only if it's a loyalty breach that you actually have some type of problem.
Well, this is a good segue. We spent a lot of time on banker complex. This is a good segue right into, before we take a break, the MFW decision and whether or not you can get business judgment review now for a controlling stockholder transaction. So, Your Honor, do you want to start the discussion?
Well, unfortunately, I've been talking a lot, and I've been talking too much, and I apologize for that.
Well, that's why we're all here.
And unfortunately,
to listen to you.
John assigned this part of the panel to me, so you have to actually listen to me a little bit more. MFW is part of our goal to achieve Joe Allerhand's dream. MFW is part of our wish that says, hey, is there a way that we can tell people up front as early as possible what the standard of review is? And not only that, but is there a way that you, directors, and your advisors can actually do it right? I mean, imagine Professor Myers is a professor at a fine law school. Imagine that you have studied with him. You have done everything that you think you should do, and you do his exams, and he's grading your exams, and you've answered every question on there, and no matter what you do, you get an F. No matter what you do, you get an F. Very frustrating. You've taken this class 3 times. Every time you get an F, you're like, what's the problem here? What am I doing wrong? All right? What we would like there to be is a situation where we can say to people, you know what, you did it right. And you're not going to have to go to trial to show that you did it right. You actually did it right. And it all comes back to standard review. So the basic issue, again, as Joe outlined, is historically in controlling stockholder transactions, since a decision called Conn v. Lynch, these reviewed as transactions that essentially you always had to subject yourself to entire fairness. Could you prove they were entirely fair? Sure. But you essentially had to go to trial to do it. It didn't matter what procedural protections you put in. If you put in a committee, you didn't get out of entire fairness. If you put in a majority of the minority vote, you didn't get out of entire fairness. There was no way to do it. So what then Vice Chancellor, later Chancellor, now Chief Justice Strine suggested is, hey, you know what? What if we said to people, if you do both of these things, we'll actually give you a deferential standard review. If you mimic an arm's length deal by having both an independent committee and a majority of the minority vote, so the controller steps back and says, I'm doing this as if it's an arm's length deal, shouldn't we give you some benefit that gets you out of entire fairness? Shouldn't you then be able to not automatically get an F? So the Chancellor, in a series of decisions, and particularly MFW, said this is a good idea. And the Supreme Court has now said on appeal in MFW, we affirm that. We think it's a good idea. But there are 2 little caveats. Part of what our current Chief Justice and part of what I think Chancery has been trying to do is, again, advance the time period at which we determine standard review. So part of what was the avowed purpose of this move in the Chancellor's jurisprudence was, let's create a situation where you can actually evaluate these things at the pleading stage. Just like we can look at a complaint at the pleading stage and say, in a business judgment context, no, directors, you get an A. Go home. Even in a Revlon context, there are times you can look at the pleading stage and say, no, this is fine. Move on. You couldn't do that in an entire fairness test. So what he was trying to do was set up a situation where you could look at it at the pleading stage. It's not clear from the Delaware Supreme Court's affirmance whether they are on board with that yet. They seem to be focused on the fact that it was a summary judgment post-discovery analysis, and if you want to sound, really hip and knowledgeable of Delaware law, you go around and say footnote 14. I'm deeply troubled by footnote 14. The implications of footnote 14, I think, are uncharted. Well, footnote 14 is a footnote where the Supreme Court drops a discussion, and they say, we think the complaint in this case would have survived. And the complaint in this case in MFW was a pretty bare bones sort of complaint. It was the type of complaint where if footnote 14 is the law, nothing really has changed at the pleading stage. Now, footnote 14, the pleading stage wasn't before the Supreme Court in MFW. So technically, there's a word for that. What's the word, John?
Dicta, I think.
Dicta, yes, you know, and they don't like dicta. At least they don't like us doing dicta. And they have some very strong opinions on the non-binding nature of dicta. So part of me thinks that I'm going to get some skilled advocate like these gentlemen to my left and right coming to me and saying, Vice Chancellor Laster, be confident. Footnote 14, dicta. You need not go forward. And I'm going to have to decide. I'm going to have to decide whether I can, because I know I will be chastised if I'm wrong. It will not be a pleasant situation.
I would have trouble. I think the case law makes it difficult to make that argument, but I'm sure, given the opportunity, one of us will try. But the problem is one of the conditions announced at MFW, and it's the fourth condition, and that is that the special committee meets its duty of care in negotiating a fair price. Now, before MFW, the Delaware Supreme Court in the prior year in southern Peru had an opportunity to decide, what is the standard that gets applied to a special committee. And even if the committee is independent and fully informed, it appears that the court's obligation is to determine whether or not it was well functioning. And in order to do that, you have to look at the substantive decisions. And so here's a quote from a 1997 case, and the Delaware Supreme Court in southern Peru, affirmed this rule. And it is, let's see, it's on page 15 of your materials. And it says, quote, I'll look back at the substance and efficacy of the special committee's negotiations, rather than just a look at the composition and mandate of the special committee. And what that tells me is every member of the Court of Chancery has sort of a safety valve to put the brakes on a transaction that might otherwise qualify for the MFW standard of review by taking a quick look at the substantive decision-making of the special committee. The problem with that is exactly what the Vice Chancellor or the Chancellor at the time expressed in southern Peru, and it just makes this very, very difficult to determine early on. And the utility of special committees is just very uncertain.
I mean, the question would be, so having the safety valve is good, because if something really looks stinky, like you want to be able to take a harder look at it even if there was process compliance at the pleading stage. The question will be, if you look at it and you've looked at the complaint and there's really nothing there and you make a pleading stage determination, will that language then result in a reversal and you all having to go forward? And that's, I don't know. And I think to the extent the defense bar wants to make that argument, you should think about the right context in which to make that argument. So MFW, the lawyers there did a really good job making sure they had an outstanding record in which to make the MFW, we want business judgment rule argument. And I think to the extent somebody wants to take the pleading stage position, that's you ought to think about what the right case is to try to
Footnote
go on
14 is the problem, though, right? Yeah. Because the Supreme Court basically said if you want to challenge the process and in particular the fairness of the price, it's going to necessitate discovery. So how do you get that argument over the finish line on a motion to dismiss?
I'm looking forward to seeing it.
Well, we'll definitely give you the opportunity because I've had, it's funny how clients think, they're very sophisticated in the M&A world, a lot of our clients, and some have said pre-MFW, why should we put in a majority of the minority provision now going into the deal? Let's hold that back in our pocket. That's a goodie we can put in to settle the case. We're in the middle of the process. Let's not spend that currency now. And obviously, I think the Chancellor's opinion was really kind of brilliant from an economics point of view. I'd be curious what the professor thinks. But he said that if you encourage companies to put in these procedural safeguards early on, it arguably will lead to tougher negotiations. There's a double check on the controller. You have to get past the special committee to approve the deal. And then you got to get a majority of the unaffiliated shareholders to approve. And that should lead the controller to actually pay more as a matter of economics. That's pretty, interesting stuff, for a judge to write. And actually, I think very savvy. The problem is then the Supreme Court comes along and puts in footnote 14, which basically says you can do all that stuff, but any good plaintiff's lawyer, all they have to do is allege that there's a disclosure problem. And then you don't even have the prong which says it's been approved by an informed vote of the shareholders. So it kind of waters it down, and as a practitioner, the client says to you, well, put it in now, Joe, or put it in later. If you put it in now at the outset, you're telling me we're going to win the case. Well, I'll say if you get in front of VC last year, you got a shot, because you have a judge who will take the risk, and maybe you'll win.
That's only because I know you'll be defending me if I rule in that way.
Exactly.
Yeah,
great vigor and pleasure.
Exactly.
And,
this is a great decision.
But you know, it really is a problem on the side, because I had a client yesterday, it's so funny, he said to me, well, they own a controlling position. They said, well, if we go down the road, we know there's going to be litigation, but what's the gold-plated standard? Tell me what we should do. And, you know, it's a funny it's a very interesting question, a fair question. A client said, tell me what to do, what's the gold-plated standard to avoid, you can't avoid the litigation, okay, to win litigation. And it's not such a simple answer, really.
But it's not only not a simple answer, it's an expensive one to get to the answer. Because it's going to engender lawsuits, it's going to engender litigation, and without a clear standard, without a standard by which acquiring or acquired companies can do their due diligence, they're going to enter into litigation always with the fear that one, it's going to be expensive. Two, I'm going to actually have to try this case. And if I do that, at best, it's a 50-50 shot, win or lose. As Joe said earlier, usually when you get to trial, it's already a tentative loss. You're fighting uphill all the way to win that case. So what I'm hearing is a lot of the theory and a lot of the arguments. But what I'm also hearing is, as a practical matter, plaintiffs' attorneys will continue to bring these lawsuits because they're fact sensitive. They will get discovery because the standard has to be determined, which standard applies. It will be a protracted process, perhaps even on an expedited basis, in which case maybe you're running parallel tracks. And then when you put all that in front of the client's going to say, this is really an expensive proposition, and oh, by the way, I have a business to run. And I have this company that I'm acquiring, and I really need to move forward with that business because the next lawsuit I'll face is one that says I didn't integrate businesses quick enough, and that had a deleterious effect down the road. So I understand the arguments, but I look at the practical part of it and I say, I think from a practical perspective for clients, it's a very difficult unknown that they're walking into, not to have these standards defined.
And that's why they buy insurance. You should be thrilled.
Some of the potential perhaps solutions to the litigation problem we will tackle when we return from our break, which we're going to take right now for 10 minutes.
Thank you.
Thank you.
Baby, take it easy on me. Anything for me to say, call me what you want to be. I open my heart to be. You are my priority. Can't you see you've punished me more than enough already? Baby, take it easy on me.
Even if I did, I don't know if I would quit, but I doubt it. I'm taken by the thought of it. And I know this much is true, baby, you have become my addiction. I'm so strung out on you, I can barely move, but I like it, and it's all because of you, and it's all because of you, and it's all because of you, and it's all because never get enough. She's the sweetest drug. Think of it every second. I can't get nothing done. Only concern is the next time gonna get me some. No, I just stay away from, 'cause it's no good for me. I try and try, but my obsession won't let me live. I got a problem and I know what to do about it. Even if I did, I don't know if I would quit, but I doubt it. I'm taken by the thought of it. And I know this much is true, baby, you have become my addiction. I'm so strung out on you, I can barely move, but I like it, and it's all because of you, and it's all because of you, and it's all because of you, all because never get enough. She's the sweetest drug. Ain't no doubt, so strung out. Ain't no doubt, so strung out. Over you, over you, over you. Because of you, and it's all because of you. Never get enough. She's the sweetest drug. She's the sweetest drug.
Sunday morning rain is falling. Still sun covers here some skin. Crosses shrouding us in moments unforgettable. You twist to fit the more where I've been. But thing just gets so crazy. Living life gets hard to do. And I would rather hit the road, get up and go if I knew that someday it would lead me back to you. That someday it would lead me back to you. That may be all I need, and darkness is all I see. Come on, let's you boys with me, driving through on Sunday morning, and I never want to leave. Fingers trace you every I'm trying. Oh yeah, yeah. Paint a picture with my hands. Oh. Back and forth we sway like branches Bounced off of love, I didn't need the pain. Once or twice was enough, and it was all in vain. Time starts to pass, before you know it, you're frozen. But something happened for the very first time with you. My heart melts into the ground, found something true. Everyone's looking around, thinking I'm going crazy. But I don't care what they say, I'm in love with you. They try to pull me away, but they don't know the truth. My heart's crippled by the vein that I keep on closing. You cut me open and I keep bleeding, keep bleeding.
if everyone could go ahead and sit down now, we're going to get started so we can get you out of here on time. Thanks.
Okay, we're ready to resume, and lest you think we were ignoring our good professor, he's going to get to talk a lot now. And he's going to solve for us the multi-jurisdictional litigation problem, to the extent that's a correct characterization, that we've been dealing with in Delaware now for several years.
And the great thing about minor is we all walk around, we like toss around these adages about multi-jurisdictional litigation and how frequent it is and what a problem it is, et cetera. He actually has data. So he actually knows.
So I'm just going to spout numbers at you. So we've been talking a lot about the standard of review for transactions, but really a standard of review is only as good as the enforcement of that standard of review. And this multi-forum pattern or problem, at least in my view, really corrodes any kind of design that goes into something like MFW, right? How good is something like MFW? Well, it depends how it gets enforced. And I think this pattern is very important to thinking about contemporary enforcement in corporate law. So what we're talking about are the filing of identical complaints in more than one forum. If you have identical complaints filed, say, in the federal system, they can be consolidated. But the pattern that is so prominent now is the filing of identical corporate complaints in, say, the headquarters state, the incorporation state, and often federal court, say with a proxy violation stapled on. This is a pattern that gets a lot of attention in the merger context, but I want to emphasize it's a pervasive pattern in stockholder litigation. Matt Cain and Steve Davidoff have very good data on merger litigation. They've shown this explosion of fiduciary class actions challenging deals. In 2013, I think something like, it rounds to 100%, 98%, 97% of deals over 100 million or 150 million face some fiduciary class action. And they find 45 or so % of those, it's been going up or down by a few % in the past years, have multi-forum claims. I think this is only the most visible situation where this is happening. And it's not just something that afflicts Delaware firms. It affects non-Delaware firms just as much as Delaware firms, and it touches all types of stockholder litigation. So I've looked at litigation, say, over stock options backdating. I've also looked at merger litigation, like Cain and Davidoff. But across both of these types of litigation, what you see is that this is a pattern that afflicts non-Delaware firms as much or more than Delaware firms. So some people have tried to explain this as an escape from Delaware, but it's not. It's a more pervasive pattern. Over 60% of firms, for example, in the backdating litigation, all faced multi-forum claims. And I've looked at a few, these backdating, to refresh your recollection, were all stockholder derivative claims, not fiduciary class actions challenging mergers. If you look at any large corporate scandal, an FCPA investigation, the phone hacking scandal at News Corp, if you look at any of these, if it rises above a certain level of news interest or predicted settlement value is my explanation, you're going to see the multi-forum pattern. I suspect any shareholder suit that's not covered in other words, by SLUSA or by the federal regime is going to attract multi-forum filings if the ultimate predicted settlement amount is high enough for plaintiffs' attorneys to fight over control of the case. I think at this point you could safely infer that if a shareholder claim doesn't attract multi-forum filings in the absence of some kind of forum selection clause, that it has little merit. Right? Any meritorious claim will attract multi-forum filings.
So Minor, let me stop you just for 1 second.
Yeah.
Maybe put to rest a rumor. I thought that people were escaping Vice Chancellor Laster when they ran to other jurisdictions. And so if it's occurring in other jurisdictions, who are they escaping there? And are they escaping them, they're running from themselves.
I don't think it is. I don't think it is a question of escaping Chancery. I mean, and I think even when it comes to Chancery, right? If I am a plaintiff's attorney with a bad case, maybe I do want to try and settle that outside of Chancery. If I'm a plaintiff's attorney, if I'm a defense lawyer facing a good case, I might like to settle that outside of Chancery. I think what's happening at firms, non-Delaware firms, is really the larger pattern of what's happening at Delaware firms, and it's competition among plaintiffs' attorneys for control of the claims. Right? If you see three people have already filed in Delaware, do you want to be the fourth filer competing for lead counsel? Right? The only way you put food on the table is to earn a fee. The only way you get a fee is being part of the leadership structure. If you're not part of the leadership structure, why waste your time? If you can go file someplace else, and you can get control over that claim, you're not going to get, maybe you can fragment the case, right? You're not going to get control over the entire case. You'll have control over your own little piece of it, and that'll give you a seat at the bargaining table. Right? You'll be able to exact some tribute. Maybe you'll be able to settle the case there. Maybe you can get a motion to expedite in Central Illinois. And if not, maybe you can threaten to show up and object someplace else. There are more routes to a fee with multi-forum litigation for more plaintiffs' attorneys.
So Professor Griffiths at Fordham has written an article that says, hey, this is all part of a well-functioning market for preclusion.
Yeah, I mean that's
why isn't he right about that? Why isn't this a well-functioning market for preclusion?
If I'm a corporate defendant, it is a well-functioning market for preclusion. But I take the view that I'm not a corporate defendant, but I'm a diversified investor in a portfolio of companies. And I'm not sure that a system that, to my mind, overcompensates bad claims and probably undercompensates good claims. But if I can get away from if I can get away from you in a good claim, I think the good claim is going to settle for less. Right? The risk in a good claim is this reverse auction. Right? If you have three plaintiffs' attorneys who can all offer the same thing in settlement, a global release for all the defendants, right? And each plaintiffs' attorney group, the one in Illinois, the one in Delaware, and the one in federal court, knows that there are going to be three settlement offers made to the defendant group, you're going to limit your settlement demands. Right?
And that's the key point, because a lot of times the defense lawyers, justifiably so, say, this is ridiculous. We don't conduct reverse auctions. We don't ask people to bid down. We don't do this. Nobody's saying you do. Right? It's simply the knowledge that there's this competitive dynamic in place that leads people to underbid. Just like, again, and I keep going back to house examples, I think they're easy to get your mind around, right? If you think if you know that the house isn't on the market yet, you've got your shot before they actually put it on the multiple listing service, right? You're going to bid differently than if it's the first day, you're there at a open house, and your realtor tells you, and you can tell from the buzz, that these people are going to have 3 or 4 offers by the end of the day, and you really want it. You don't have to be involved in an actual open outcry auction, either up or down, to have it influence your behavior. And so one of Professor Meyer's great insights is this idea, like, it doesn't have to be explicit.
So in bad cases, in strong meritorious cases, right, there can be this reverse auction. Plaintiff attorney groups bidding against one another, bidding the price of settlement down. In weak cases, in nuisance cases, the price of peace is often you got to pay everybody to go away. I mean, that's why it's happening. So, to my mind, this is a system that overcompensates bad cases and undercompensates. However bad you think corporate litigation is as an enforcement tool, right? I think this multi-forum character makes it worse. It aggravates whatever problems there are in shareholder litigation.
I'm going to disagree with you just a little bit in terms of one of the factors that corporations face in multi-jurisdiction litigation is the cost of defense. When you're fighting in multiple jurisdictions, you don't have parallel discovery. You're making motions or have defense counsel make motions to stay litigation until that issue is decided as to where should the primary case go. Even after that primary case resolves by motion, trial, or settlement, you then face these other cases where the plaintiff's attorneys don't accord full faith and credit to the decision or to the settlement. So it engenders further motion practice to get a court out in a different state to say, we need to recognize what has happened in, for example, Delaware Chancery, and that's the end of the case. I think it's more than just a matter of forum shopping, judge shopping. I think there are elements here too. Even if I get a little piece of something, I may, not that plaintiff's attorneys copy each other complaints, but they write complaints that sometimes are similar, and sometimes even very similar. But you take that and you say, you know what, I've done that, I've filed it in a different jurisdiction, I deserve some type of compensation for it, even if it's disclosure based, and you go to a state where maybe the court isn't as savvy or sophisticated in business, and you look for that particular court to say, if I don't have to decide these issues, it's probably better. So even though disclosures were made in the Delaware case and a fee awarded for those disclosures, can we find something over here? Because again, you get to the business part of it, which is the company wants to integrate businesses. They want the merger, they want the acquisition, they need to move on, or it gets tied up. You have judges, for example, that hold decisions for 3, 6, 9, 2 years waiting to decide a motion to dismiss, and that just kills a company because how do you move forward?
Well, I totally agree, but I think that's part of my point about the bad case, right? If a bad case settles in Delaware for a disclosure-only settlement, and then you have to go relitigate it in some other jurisdiction, that's just increasing the cost of making that bad case go away. If all those cases were forced into, say, Delaware, it might never get filed, right? Not only because a Delaware vice chancellor, not having to worry about, say, competition from somebody else, might say, forget it, don't even bother bringing this junk in front of me, and there'd be no other alternative.
And it sounds like you're heading towards an exclusive forum discussion.
You know, back when I first started writing about this, I had a more ambitious program, this federal reform that could coordinate litigation by removing non-incorporation state cases to federal court and staying all federal litigation in favor of a filed incorporation state. The world has passed me by. And so the forum selection clause, you know, thanks to a couple recent decisions, I think is really starting to take off.
So that, I would just, before we get to that, what do you do in the real world when you're a defense attorney and now you're defending a deal and you have lawsuits in Delaware, state of incorporation, and maybe some other jurisdiction? So I have 3 different approaches, and I have a question for the Vice Chancellor. The first approach we do is appeal to the finer instincts of the plaintiff's bar, which never works. We write a letter and we say, plaintiff's lawyers, you're purporting to represent the shareholders and a class. It is not in their interest to have lawsuits in multiple places. Would you please huddle up, have a cup of coffee, maybe a drink, and work this out and let us know where you would prefer to litigate? You know how often that succeeds? Never, but we do it anyway. Then we have the jump ball approach, the Bill Savage motion approach, I call it the Pick'em approach, where on the same day we file identical motions in all the courts, and we say, Judge, we got a great deal here, we're not worried, it's bulletproof, business judgment rule, we'll litigate in any court that wants the ball. So talk among yourselves. And we're happy to proceed wherever we're told to proceed, but what we're not happy to do is proceed everywhere at the same time. And then we have, obviously, motion practice, where you move to stay everywhere in favor, typically, of Delaware. And what I'm always surprised is, on the second approach, why don't judges, is there something you learn in judge school that says you're not allowed to pick up the phone and call another judge? Because you'll do it. But it's amazing when I'm around the country, people, they just don't want to pick, you know, they're afraid to pick up the phone.
Yeah, I don't know.
I don't know why that is.
We do it. Now, I mean, I'll tell you, the phone call approach works until it doesn't. So, I mean, the phone call approach is very effective if both sides, both people on the phone are cooperating and neither feels very possessive about the case. It doesn't work in resolving disputes where you actually have a dispute. So that's why I say it works until it doesn't.
You know, I was in New York yesterday in front of a judge in the commercial part. She's still smarting from the chancellor's tongue lashing and beating. I think it was the Topps case. And this is years ago. And so I could see why, you know, judges are not used to being yelled at or admonished, at least not generally in the courtroom.
Yeah, and I mean, so that's the other thing. So the direct phone call, and the direct phone calls I've had are usually been pretty pleasant, but as I say, they're not always effective. The other way is we do communicate to each other via transcripts, and you know, I always try to be very respectful of those too, because I think part of what we have here, and I think Miner's data shows it, you have a situation where everybody is being individually rational. So as he describes it, each one of the plaintiffs is making an rational individual maximizing decision. The defendants, by settling these things, are making a perfectly rational decision. But what we have as a result is collective irrationality, where essentially we just have a massive multi-million-dollar burden that nobody's really sure where it's coming from, and we lose in terms of understanding which cases ought to be litigated and which shouldn't. I will tell you that when I decide these things, so one of the first things I look at when I first check offs is, has the other court done a lot? So I had a case where it had been in Texas, I want to say like a year-ish. Court had already done a lot had touched the case a lot, was involved in the case a lot, and then second filed case comes into Delaware saying, hey, it's Delaware Corporation, Delaware Choices of Law, or Delaware Law, really important issues, we really think you ought to decide it. That didn't seem to me to be a very good use of judicial resources. So if the other judge has already expended a lot of resources, that's a big one for me. Then the second, I try to take a realistic approach to this, in that I do look at strength of claims, and if it is a junky lawsuit, I really don't care where you litigate it. In fact, if it's a junky lawsuit that's going to get settled out for junky disclosure, I would actually rather have you do it somewhere else. Now, I mean, this is some of the professors, not Professor Myers, but some of the professors said, oh no, if these cases leave Delaware, won't there be a loss of the supply of Delaware precedent? Won't there be a dearth of guidance? You all are getting no guidance at all from us in these settlement rulings. If anything, you're getting like conflicting noise. I mean, the signal to noise ratio is very skewed in these types of rulings. So if it doesn't look like it's a terribly strong case, it's very easy for me to talk to the other judge and say, you want it? I see a lot of these. You want this one? It's great. You know, go ahead. But then the third situation that I think about, and I think it's legitimate. The multi-forum problem and the multi-forum decision is as much a counsel selection decision as anything else. That's the reality of how the plaintiffs' bar approached it. That's what you just heard Miner explain. The plaintiffs are trying to jockey for position as to who controls the case. So I am perfectly happy to take a realistic view and say, okay, I will think of it as a plaintiff's counsel selection decision as to who controls the case. And I will think about it, do I have the strong hand in Delaware? Or is the strong hand someplace else? Because look, I think that junky cases ought to be thrown out or not filed, and real cases that have real merit and it looks like something ought to be looked into ought to be litigated so we can find out if there is actually a problem or not. And I think that real cases that ought to be litigated by the people who can best litigate them. I mean, if you were hiring a lawyer, a paying lawyer, you were going to pay them to bring a plaintiff's case, you wouldn't be like, well, I got these 7 different people and this time I'm going to pick that guy. You would actually say, okay, I want the person who can do the best job. I want the person that actually has a track record of success. So I will think about, and I will think about not only the lawyer but also the client. So if it looks like I have maybe in front of me, a relatively uninvolved, small holder who isn't likely to participate a lot, I will factor that in. And so if the strong hand is elsewhere, I am more likely to defer. And again, I don't know, some people may have strong objections to that, but But I view it as a realistic assessment of what is actually going on in terms of the multi-forum situation, which is, as I say, if not entirely, but largely a council selection decision.
So,
You offended by that? Tell me.
no. So,
You're allowed to be offended by
Well,
that.
I'm not offended by it, Vice Chancellor, but one question I do have would be the thought of inviting plaintiffs who file in multiple jurisdictions into, for example, your courtroom.
I do. They don't always take me up on it, but I do.
And I appreciate both sides of that, but then the question I have to you is, doesn't that also promote increased plaintiffs' fees when you're inviting 2, 3, 4 different plaintiffs' attorneys into your courtroom, so that instead of an entity paying what might be $400,000 to $600,000, it now, because you have 4 attorneys actively participating in settlement negotiations, the fee becomes $2.5 million.
So not when I think about it. Like, I get it when Joe comes to you and says, hey, look, I've got, they're telling me they got a lot of mouths to feed. There's 14 firms over there. They're asking for 7. We really need to get this done at 7. Maybe if you only had 4, we could do it at 5, yada, yada. Like, I get that that's maybe a tactical consideration on your side. But when
it's not. I still pay only $400 to $600.
Well, that's how I think about it too.
He's a good attorney.
There you go.
So
there
we're
you go.
together. Good.
But when I think about the fee application, no. I mean, and in fact, if it's almost like it's not a red flag, but it's a yellow flag. Like if you have a long, lengthy list, like if your committee of the whole is like, it looks like the 12 leading firms from the New York plaintiffs bar. I mean, that's a bad sign, because that's what I'm starting to wonder. I'm starting to wonder about duplication of effort. How did all these people get anything done? Why wasn't this terribly inefficient? Like, why would I give you 7 or 8? So only put 2 or 3. It's your tip.
You have a question?
Just a quick question for Joe. So there has been a trend in some of these cases to, if the concern really is the cost of the litigation, why allow coordinated discovery? Why allow those cases outside of Delaware to get traction at all?
So I think on the coordinated discovery front, the nightmare for the defense lawyers to have your CEO deposed 2 separate times. And obviously, since you know that most of these cases do end up in settlements, there is a institutional push, if you will, to coordinate the discovery, because when all the plaintiff's lawyers are in the room at the key depositions, it's much easier to talk to people, and I find it ultimately leads to a more coordinated approach. I do have partners who take a much harder, hawkish line, and they always fight expedited discovery, which is not something I always do. They always do. And they always fight multiple proceedings. And maybe they're right. Their view is it's such an evil that if you fight all the time, most of the time you'll generally end up better than if you go along. I'm not sure they're right. That'd be an interesting thing for the professor to study. But I think it's just practicalities, because you can't have your CEO deposed 2 times. And what do you do when you're in a forum outside of Delaware where the judge always allows discovery? I mean, you have to understand, when you get out of Delaware, you don't have much of a chance of defeating expedited discovery to a judge. You're coming in saying the plaintiff can't have discovery. Why not? That's what they do. They give discovery. I have a case in front of a judge in Texas. Her election campaign platform was redistribute the wealth. If you elect me, I will take seriously the notion of redistributing the wealth. So if you're representing one of the richest men in Texas, that is not a forum you want to be in front of.
Joe, that's a good segue into what are the solutions? Because, Your Honor, we've been living with the status quo. We've got the Sabbath motion approach. We've got the stay approach. Despite your best efforts, we still have all the statistics that the good professor is bringing to us. And one of the problems, of course, is if you have a judge in a jurisdiction where they are elected and they have lawyers standing before them who have donated to their campaign over the years, and they're going to want them to donate again, despite the best effort they can engage in to try to remain unbiased and so forth, it's very difficult for them to let go of a case when there's so much money at stake.
And that's the optics, too, to answer this gentleman's question. I do think it's rather awkward, and it's even awkward if you're in front of me and I try to understand the dynamics that are involved and be sympathetic to the problems that it creates. But the court's going to say, well, have you given discovery to anybody? And the defense lawyer has to say, well, we gave it to those guys. We didn't give it to your people. We gave it to those guys. And the judge may not see it as oh, that makes sense because you're trying to corral another forum. The judge make people, wait, you know, what's wrong with my forum?
Well, and this may not have
What's
happened
wrong?
to you, but you don't really know how to relate to the dynamics of having to raise several $100,000 or even $1 million to run a campaign.
I couldn't do it.
So what is the? It seems that the exclusive forum provision is a pretty good solution to this problem. So why isn't ISS pushing it? And Kieran, for example, why isn't your industry saying, for example, we'll give you a lower premium in your coverage if your certificate has an exclusive forum provision in it?
I won't speak on behalf of the company as to why, for example, you wouldn't move in that direction, but I can offer some thoughts as follows. First of all, it's untested. The exclusive forum clause has been upheld in Delaware, but there's nothing that has said other states will recognize the exclusivity. The second problem with it is you have plaintiffs' attorneys who are savvy enough to turn around and say, not only will I bring it in Delaware, but you know what? There's another plaintiff's attorney who's going to bring it in California and allege violations of California corporate law, incorporate that into a complaint. Therefore, arguably, it's a shade different, and maybe it's not just within solely the jurisdiction of Delaware. You also have to give it some time to play out to see how this does work and whether or not full faith and credit does. Now, I can see where corporations, and we can go back to the Chevron case and FedEx cases, which were the keynote cases on this issue. When this started, there were 12 companies that made exclusive forum clauses part of their bylaws. And then there was a whole discussion of, well, should it be bylaws and should it be charters? And if it's bylaws, well, shouldn't the shareholders have a vote on it? And even for those bylaws that say, hey, or the certificate of incorporation says, hey, the board of directors can do what's in the best interest of the company, not necessarily with a shareholder vote. At some point in time, those shareholders can have a vote on that. And the ISS and the Glass and other shareholder service companies may turn around and say, you really need to vote that down because if we're in Delaware, that is known as a jurisdiction more friendly to business. I happen to disagree with this statement, but that is a nomenclature that's been out there for ages. Maybe we want to be in the Southern District of New York. Maybe we want to be in California, where plaintiffs have had better luck or better fortune in prosecuting these cases. So I think the first dynamic is, let's see how this plays out. The second is, you can't turn around and start saying, well, let's incentivize companies to maybe undercut shareholders, because then what are the optics of that before the court as well? And on the other hand, plaintiffs' attorneys, again, are savvy enough to move around that and say, hey, you know what? We can allege violations of North Carolina business law and Nevada law or California.
So here's, I mean, I'm gonna be a little more jaundiced. I think the insurer is in the same position as the defendants. And so what Professor Meyer points out is, if you're the defendants, you like the option of having another forum, because if the situation is that it is a credible case, you want to be able to settle it for the least amount possible, which means looking for the weak hand in the weak jurisdiction. And you know, who knows? Maybe Delaware's the weak hand in the weak jurisdiction. I don't know. But you like choice, right? So you know, it's not clear to me that, again, from an incenting perspective, that the insurer has the incentive to do that. But that would also mean, now I'm going to second guess my own statement. The same logic would mean that defendants don't have the incentive to do that, and we certainly see them putting it in. So Professor, solve this problem. Solve this problem.
I can't. I mean, my fear would be that if you're a company that thinks, you know, a big derivative suit, like a meritorious merger class action, maybe in my future, yeah. I want to preserve the optionality.
Optionality is good, yeah. As long as it's working your way.
Of settling it cheap. So my worry would be that forum selection clauses don't get adopted as rapidly as shareholders might like.
So how about this as a solution? We tried it in 1983. It didn't go anywhere. Exclusivity of appraisal.
You know, I think that's pretty good.
Segue into appraisal.
Okay. Appraisal, well-known remedy in corporate law, right? You forego the merger consideration and instead file a judicial proceeding that will determine the fair value of your shares. And the judicial proceeding uses the same kind of tools that a banker's fairness opinion uses. Well-known, little loved in corporate law circles over the years, but over the past few years has been exploding, especially in the past year, has been exploding in its use. I've done a lot of work on this with a co-author, Charlie Korsmo, who's at Case Western, and we have a relatively sanguine view of appraisal activity. We've looked to see, well, this new breed of appraisal specialist, what kinds of deals are they targeting among all the universe of appraisal-eligible transactions? They're targeting deals with abnormally low merger premium. That is, they're targeting deals where it's a bad deal price.
Now, compare that to traditional stockholder litigation. Is there predictability based on premium for traditional stockholder?
No, there's no relation. So we have a paper where we compare. You look at this whole universe of appraisal-eligible transactions. Some of them attract appraisal activity, 80 of them. A far larger number attract fiduciary class actions. So what's related to what? Well, what predicts appraisal activity? Well, it has nothing to do with merger size. Right? A bigger merger is not more likely to attract a larger appraisal group. But it is strongly related to the merger premium. The lower the merger premium, there's a very strong relationship to attracting an appraisal petition and a very strong relationship to the size of the appraisal class, though they've been only exploding in size in the past year. There's also a strong relationship to a controlling stockholder transaction. Controlling stockholder transactions are much more likely to attract appraisal petitions. And these are, you know, in the corporate law academic world, these are the transactions where you want to focus private enforcement resources. Fiduciary class actions, there is no relationship between the incidence of a fiduciary class action and the merger premium, no relationship between the incidence of a fiduciary class action and the controlling stockholder transaction. It's all related to deal size, which suggests it's all related to some kind of nuisance value settlement that is a fraction of the transaction size. Not encouraging findings for fiduciary class actions. This rise in appraisal over the past year, 3 years, it's been stark. You know, in 2013, let me go back. Between, say, 2004 and 2010, maybe 5% of appraisal-eligible transactions attracted some kind of appraisal petition. In 2013, nearly 20% of appraisal-eligible transactions attracted some petition. And
let me stop. I think this is key because that growth alone, like that sounds bad, right? I mean, we've gone from 5% to 20%. That's a fourfold increase. Like even when we were talking about the explosion in merger litigation, it was going from like 40 to 50% of deals covered to all deals. I mean, that's only doubling. So I mean, fourfold, that's like bad. And you have a lot of defense lawyers saying, oh my goodness, all this appraisal, this must have all the same problems, all the same pathologies as stockholder representative litigation. But again, what I hear the professor saying is, well, no, actually, if you look at these things, if you came up with a list of transactions, so think about last year triaging his deals. I told you I look at whether a case is strong when it comes in the door, and I'm thinking, okay, is this one that actually should go forward, et cetera. What are some of the things I look for? Well, I look for, is there a controller with a conflicting interest, right? I think about the size of the premium. I mean, the premium isn't directly indicative, but all else equal, more money's better, right? You know, I look at board composition, things like that. None of those things are true about class action litigation. It's like nobody's triaging at all, which we know is true. Why? Because every deal gets sued on. You can't triage if you're going to sue on every deal. But what Professor Myers is finding is in the appraisal context, what do you know? People are actually picking their spots.
I mean, look, if you think about fiduciary duty litigation, nobody cares. It's all about process, right? All the standards of review is all about process. Nobody, if I'm an investor, I don't care about process, right? Process, the only reason that a court looks at process is as a proxy for is it a good price or not. Did you engage in some process that gives me some confidence you're going to end up with a good price? But it's all ultimately about the price.
Have you looked at the nature of the plaintiffs in these cases too? Because I suspect that, well, it has to be the case that you don't see the individual with the minor holding engaging in the appraisal process because they just can't afford to do it.
I mean, appraisal, you have to put your money where your mouth is, right? You can, I can own one share of, Acme Corp and show up and purport to be there in court on behalf of billions of dollars of equity value of Acme. In appraisal, you're only going in on with however much you're willing to buy. That's one of the features, right? There are some defense lawyers who think that's a bug of appraisal, that you can buy into the claim. That is a feature of appraisal. That's why it works well.
Question?
So doesn't the combination of statutory interest and public offer price limit the downside risk for what we increasingly
Because you can get less.
hedge fund arbitrageurs who come late to the game?
Well, it depends, right? Because there was a trend in our law, and we don't know where it's ultimately going to go, for the court in public company deals to say the market set the price, and then they back out synergies from the merger consideration, you wind up with less.
Petitioners have ended up with less. It's maybe 5 to 8% of petitioners, but that's a real risk. Moreover, I don't know. 6% sounds great in an extremely low interest rate environment. You're an unsecured creditor of a potentially highly leveraged company. You are illiquid for possibly 2 years. I'm not sure these are hedge funds making interest rate plays so much as specialists in pursuing this type of corporate remedy. The same way you have private equity, you have people who specialize in things.
So do you think, though, Professor, just now I'm asking more of an economics question, that so now we have two ways to set market prices in M&A deals. You have the market sets the price, and then we're going to have the judiciary set the price thereafter. I mean, is that a good use of judicial resources, and is that really what judges are supposed to do?
I think there's a lot of reasons to be. In a way, this gets back to process, right? What you're trying to do is pick some mechanism that offers the best price, right? If you have an auction, right, the RJR Reynolds case comes to mind, right? I can't imagine second guessing that, right? As talented as I think the
but when you say you can't imagine, that's exactly what happens in the appraisal proceeding. Each side hires an expert, but go ahead, maybe help us, because there's not enough of a track record yet to know how all these appraisal proceedings are going to play out, but everybody hires an expert, and I promise you can hire an expert to second guess the best run auction and say, if you really did the analysis right, you come up with a higher number. Yeah. And doesn't the judge now have to make a decision and not come up with a range of numbers, but actually pinpoint?
You can, but it ain't gonna happen. So again, like what Miner's saying, and I have this situation quite often because there'll be projections, and somebody shops the company to 40 different people, they get a market price, etc., and then they come in and appraisal and say, but the projections in the DCF, they showed this was $10 worth $10 more than what they got. Isn't that horrible? Well, I look at that and I think, okay, I am a judge. I don't put my money where my mouth is when I'm doing these valuations. I'm not trained and tested based on how I perform in the market. But you had 40 different buyers come in and look at these projections, and the fact that you got the price you did means that they clearly, on the whole, haircutted these things. Again, I'm not going to second guess that. Now, what you could have is if the plaintiff shows market dysfunction. So if the plaintiff, and this is, I think, part of the tension is we do risk moving appraisal cases more into process cases because there's going to be a process component. But if you can show, as a plaintiff, particularly in an arm's length deal, you're going to have to show some reason why that pricing didn't function and why there's some reason for a court to do its own type of calculation.
And on that, I don't think we're going to get a chance to propose any kind of solutions for this to the extent one's even needed, because I'm told that we have reached our time limit. And are there closing remarks?
We can open it up for questions and answers.
Great. Question and answers. Yes, question.
I have one that maybe you could address just briefly with regard to the rural metro decision and the gatekeeper discussion. I noted in the article that's written here, and I don't know who the author is, it says, first, an advisor asserts that the traditional role of gatekeeper faces little risk of liability. And I know I read the footnote where Your Honor cited the various articles that talk about gatekeeper status, and I think most of them went to financial advisors serving in a securities role and not M&A role. So I didn't see that the traditional role of the gatekeeper actually really in M&A.
Well, you can't
Yeah,
talk
I'm not-
about it, so you want me to
Sure,
take
yeah,
a-
say whatever you want.
Well, look, I have a, I will, I usually do. I just have a little bit different view of how these issues ought to be looked at, because I didn't think it was necessary to go try to find the underlying breach to tag the financial advisor. I think that Delaware law needs to find a different way to deal with financial advisors that do what the financial advisor did in the rural metro case, because what they're really doing is they're performing part of the fiduciary function. You know, the directors aren't delegating that aspect of the decision making to the financial advisor. They can't delegate the duty. They just don't have the expertise, and so they're relying upon, they are relying upon the financial advisor for that aspect of the decision making process. And in that sense, they are performing a gatekeeper role. I mean, that's the critical part of the decision making process. Joe? Well, that's great, but that would be like me signing an engagement letter saying that you know, you can't sue me for malpractice. You know, you're just taking away the standard that it's supposed to apply to the job you're performing.
Other questions?
Yes.
Are you concerned about the rise in shareholder activism? It seems like maybe the barbarians have found a way around the gate. In some cases, only 10% of the stock is now required to gain control in some instances. So I think you know, it's certainly a concern, you know, that we have, and I wonder if the court and the panelists also share that concern that the game has somehow changed.
So I don't know if my colleagues may, I don't know. I mean, my perspective on this is I'm a trial judge. I'm a trial judge in a state that is a very small state population-wise. It's a very small part of the economy. We have a privileged position in that we are entrusted with the corporation law that governs a lot of the entities. I am agnostic, studiously agnostic on a lot of these public corporate governance positions that people go back and forth on. I think my job is to apply whatever your entity-specific arrangement is, and that consists of, you know, first of all, whatever statute you've opted into, so usually DGCL, then your charter, then your bylaws, plus whatever common law overlay there is. And I'm supposed to look at what your entity-specific relationship is and call it as best I can as to that. So I don't take a stockholder good, management bad, management good, stockholder bad perspective. I think everybody's got interests. I think interest is what makes people do things. But you know, my job is, rather than coming at it from a normative perspective of, you know, oh, the activists are at us, or oh, you know, management is overcompensating themselves, or all these issues that get people so fired up. Again, I think I'm supposed to look at what your entity-specific relationship is and call it as to that. So I will beg off the big questions on that grounds and defer to my colleagues in terms of the more overarching issues.
Well, the one concern I do have, and which has been spoken of in closets and outer rooms, is the number, the percentage of merger and acquisition cases that end up in litigation. 3 years ago it was 96%. It's only increased since then. When at a time everyone looked at 96% and said it's ludicrous to think that 96% of mergers should be subject to legal challenges in at least one form, if not multiple forms. We're now up over 97% of these cases. In some instances, disclosures. In some instances, there are absolutely details, and we've spoken on some of them today, of cases that need to be challenged by the shareholders. But then somewhere I think, and I would challenge people to think, have we gone too far? Are we filing too many cases? Has it really destroyed the credibility? And our company is now turning around and building in a factor that says, I know I'm going to be sued, so let's hold a little back, or let's condition something for a settlement down the road so we can really move and advance the ball forward to really what we want to do, which is integrate businesses, acquire businesses, move it from a business perspective.
And on that note?
With that, I think are there closing remarks or?
No.
No.
You just don't forget to sign out on your way out.
Buy BNA products.
Yes, thank you.
Thank you.
Good one.